Disney has said that, quote, "We are extremely proud of our impact on the Central Florida economy." Were they proud of 100,000 workers who have to sit in traffic and commute every day because there's little or no workforce housing? Are they proud of a district in which there's not a single school, in which there's not a single public library, in which there's not a single hospital? Are they proud of evading hundreds of millions of dollars of impact fees? Disney went out and launched a campaign of litigation. They went to federal court and they had a myriad of different claims. And now all of those claims have been dismissed with one exception, and that one remaining count is foreclosed by binding circuit precedent. And
in other words, the one count remaining he's referring to, and y'all have heard us cover this, Andrew and I, many times, pro as well. They went to federal court with all this stuff. Their contract violation, this violation, they won't let us, they won't let us proceed with the agreement that we forced upon RCID and bribed them with and all this kind of stuff. Now they're just down to the First Amendment. That's it. They violated my First Amendment rights, y'all. Again, still, RCID was not Disney. RCID was not a wholly owned subsidiary of the Walt Disney Company. You cannot make a connection there between the two because there is no right for a private company or any individual to own their own private government. And Ron, correct me if I'm wrong, is that probably with all this new evidence coming out, as if the obvious wasn't probably going to defeat Disney's bogus federal First Amendment claim, I would say that, if you were going to show that the relationship here was one of a very criminal nature, let's go ahead and say, bribery, public corruption, misuse of funds, multiple violations of federal and state regulatory bodies, I would think that might nullify a First Amendment claim, too. What you think?
Well, there was never a First Amendment claim here. That was always pretty bogus. And I mean, unlike Andrew, I don't know anything about Florida Special District law, but I know a little bit about the First Amendment, and that's got nothing to do with this case.
But that was a placeholder, right, to keep something in the system? It
was not just a placeholder. It was, it was that, but it also was a narrative builder. It was meant to get, media and, influencers on their side by, wrapping themselves in the Constitution. And it didn't go well.
Ron, you've been sharing with us backstage some of the details about David Thompson and his pedigree. You want to share a little bit of that with the audience out there? Is this a serious guy?
He's a pretty serious guy. Yeah, he is the managing partner of Cooper and Kirk. Joined the firm at its founding. He's double Harvard, which means he's probably a prick. But magna cum laude in 91 from Harvard undergrad, Phi Beta Kappa. So this is a guy that you would definitely beat up in the hallway. JD cum laude from Harvard, significant trial experience, and adjunct faculty at Georgetown. He's been involved in some pretty real stuff, and it is kind of interesting because he doesn't come across as necessarily. Some people are saying that he sounds like he's going to cry. You might think that the guys with the golden pipes, like Val, people who sound like that make the best lawyers. They don't always. Sometimes squeaky little people do quite well for themselves, and it looks like Mr. Thompson is someone to be taken extremely seriously. He knows what he's talking about.
This list of past clients and past litigation, holy hell, Ron.
Mm-hmm.
Gee-many crickets.
Yeah, and you notice the first section that they list there that cite is what? Breach of contract. I think we might have a little bit of that going on here.
To be fair, that's basic business law. That's what everybody does, lots of it all the time. But I'm going to give him a call when we get off. I just might want to go to work for him just to be involved in this case now that I've become such an expert on it.
We usually have Jonas make those phone calls. People talk to him for some reason we can't quite understand yet.
I can't figure that one out either.
Basically, what you're saying is that for the purposes at hand, this is someone akin to, like, I don't know, who's your favorite guy? I don't know, Michael Jordan or Tom Brady kind of thing.
This is
it's better than Matlock.
This is a guy who knows what he's doing and who, you know, seems to be entitled to a great deal of the fact that he's involved in this means, you know, this is a quality lawyer. This is not some ambulance chaser. He's an experienced appellate lawyer, and he knows how to bring it. I'm sure that he is eager to do so. Whom he would be representing isn't clear for me. What his role is in the proceedings here. Is he on the audit committee?
There were three separate auditors selected. So we had Bill Jennings, and then we had Professor Cochin from George Mason Law School, and then
now there's litigation in the state court.
Oops.
I'm just worried he may not have a network. I mean, I'm really his background. Yeah, I'm not sure about his connections.
Well,
so
listen,
the only instructions, Ron, they gave these guys was, you know, before and during your audits, during your research, do not talk to one another, because they did not want to cross-pollute each other's findings. And magically, wouldn't you know it, all three of them came to the same damn conclusion. Because
came at this from the legal perspective. It's a triangulation. We have the academic, we have the legal, and then we have the accounting forensic audit. All three of these points in space have triangulated around what was happening in this utility district with Disney.
Yeah,
by the way, I didn't get a chance to mention this earlier.
If he was on by virtue of being on the audit committee, Mike, though, now that I understand that, he probably can't be involved in any of the litigation, because that would be a tremendous conflict of interest. But he could testify about it as an expert.
Yeah.
And that might be even more valuable to to society, maybe not to his firm.
True, but yeah, I think they were probably paid handsomely for this work.
I think
this was
okay
a ton of work. Yeah. This was a ton of data research. Let me finish this up. It's only got a couple minutes left.
All right, binding circuit precedent. And now there's litigation in the state court that the district commenced in response to Disney's improperly going to federal.
That's the countersuit that the cftod filed against the Walt Disney Company in state court. Florida state court, which is what's tying up the federal case, because like, well, you got to resolve the state issues first before we move on up the chain here, which of course Disney, I think, knows that state court ain't going to go their way.
Federal court with many of the issues. And this is a dispute where there are many dispositive legal issues. And instead of allowing the court to simply assess those dispositive legal questions based on the briefing, Disney launched a round of invasive discovery, which is expensive and wasteful, and is a further example of Disney driving up the cost for the other taxpayers in the district. Disney has said that
they don't care.
Quote, "We are extremely proud of our impact on the Central Florida economy over the past century," close quote. But one wonders what they are proud of. Are they proud of 100,000 workers who have to sit in traffic and commute every day because there's little or no workforce housing? Are they proud of a district in which there's not a single school, in which there's not a single public library, in which there's not a single hospital? Are they proud of evading hundreds of millions of dollars of impact fees that could have ameliorated the transportation?
That's it. Hundreds of millions of impact fees that, guess what? SeaWorld, Busch Gardens, Universal, all of them have to pay. Would you think the environmental impact fees that Universal had to fork over just to break ground on Epic Universe? That's the problem. Everybody else has got to pay these bills. Disney never did. Not one damn penny.
Situation. The bottom line is Disney's put forth a fairy tale in which the prior governance structure was a model of good governance. But the audit shows that the exact opposite is true. And we know that the audit's conclusion is correct. How do we know that? Because throughout the United States, throughout the last 55 years, there is not one single jurisdiction that has decided to emulate and replicate this system of governance. And that is proof positive that the prior model was indeed a failure.
Boom. That's it. Make sure you're subscribed to Valiant Renegade and join us every Sunday at 6 p.m. Eastern for the live show.